My name is Lydia Goodner, NOW's Executive Director. I will be moderating today's session, True Due Diligence, Insights from the Trenches. During today's session, if you have any questions, please use the chat feature in the on the right side of the screen, and the presenter will be answering them at the end of today's session. Please join me in welcoming our speakers today, Mandy Dietz and Ryan Baker. Mandy Dietz has been conducting research for Capital Lien for over 14 years. She oversees all research supervisors and coordinators in achieving the most timely and comprehensive results for clients. She has past experience as a paralegal and also currently serves on the UCC Education Committee for the National Public Records Retrievers Association, providing industry insight to article revisions and research standards. And also Ryan Baker, Director. Ryan has been refining the art of client relations to the legal industry for Capital Lien for nearly a decade, with degrees in both management and marketing in conjunction with an understanding of risk mitigation. He leans on these skills to get to the heart of solutions for clients nationwide. He also serves on the board of the Commercial Finance Association's Minnesota chapter. Welcome, Ryan and Mandy.
Thank you. So today's presentation is going to involve war stories and the helpful insights that we want to pass along from deep within the trenches of research involving property, corporate, and UCC expertise and the lack thereof. We hope you come away with a few learned consequences of not experiencing true due diligence, as well as some helpful tips for your process. So Lydia touched on who Mandy and I are, and we'll go into a little bit about our company then for you. Just to give you an idea, Capital Lien has been in business since 1990. For those of you who don't know the role that our company currently plays in the research industry, we do have this brief video highlighting our thought process around what we're calling real research today. And that'll be an underlying theme throughout our presentation.
Is your service provider protecting you with real research at a real value? Our reach gives us the ability to service our clients anywhere, in any jurisdiction, with quick turnaround time. In doing so, we provide the pertinent information needed at the best value.
Capital Lien is the proven source for due diligence research nationwide. Our timely, definitive information is depended upon to make decisions with confidence.
As public record experts, we mitigate the risk for you, your business, and ultimately your clients. Our goal is to make you the hero to your organization.
Our ideal clients consist of legal, lending, and title professionals, or really anyone who needs a public records expert to help them uncover information.
Capital Lien's delivery of relevant search results that adhere to clients' needs and expectations is how we distinguish ourselves from other service companies. Our research is customized, and searches are conducted closest to the source, with what we like to call hand-sourced due diligence.
We only operate under transparent billing and fee structures. All of the divisions of Capital Lien are able to provide quotes before we proceed with any projects, so there are no surprises.
Providing you with peace of mind is important to us. Let our experienced team guide you through all the nuances and quirks associated with each jurisdiction.
A lot of our business comes down to word of mouth, so it's critical to impress our clients each and every day. The following are some of our favorite compliments that we've received.
Our business has
So I'll just cut it off there, but wanted to give you the idea of the way that we work. Transparency is obviously a big part of that, and then hand sourcing and going direct whenever possible to the jurisdictions and knowing those nuances. So with that, I'll continue on. Here's a picture of Mandy and I. You were able to see us in that video as well. We have presented this different variations of presentations for the legal industry, probably over the last 5 years most intensely, and for different associations across the country. All right, as far as our agenda today, we'll start by going through some property issues, then touch on corporate related insights, and lastly, we'll tackle UCC financing statements in hopes of providing some guidance on issues to avoid. All right, so jumping into property, there's some common themes throughout, one of which is what we call good legals gone bad, or more often than not, bad legals that you hope can improve. For example, a mortgage having several exceptions was filed in a county on a property with a confusing legal description. Unfortunately, proper due diligence was not practiced on the property before the mortgage was filed. When examined, it was discovered that the exceptions included all of that property. A large bank, in this case, Bank of America, was empty-handed, having a mortgage that did not encumber any actual property. In addition, the bank foreclosed on the mortgage, leaving the bank with nothing. We see things like this all the time. Usually it's a case where people once owned a large portion of property, then deed off parts of the land to others. And sometime later, the new owners take out a mortgage and the title company will go back to the original deed and use that legal description, not accounting for all the out sales that were made since the original title transfer. So technically, they are encumbering property that they no longer own because someone didn't do their due diligence when drafting the legal descriptions on the mortgage. We have a couple different examples for you. Another example, just last year, we were asked to research a property in Pine County. We found the legal description to be incorrect on the sheriff's certificate and brought it to the client's attention. Based on the deed, there was a mid-sized bank in the Midwest that technically owned the incorrect parcel. The client chose not to fix the legal description issue. Rather, they chose to sell the property and then draft a deed with the incorrect legal. Basically, they just transferred the problem. A majority of issues we address in regards to property are with legal descriptions that seem to trip people up. These will have a lasting effect until they are corrected. Ownership is quite obviously a major piece of property research as well. That said, this is probably one of the better examples of a war story that could have ended badly. In Morrison County, at one time, a couple owned about 200 acres of land. They chose to plat some of it and sell off a bunch of it over the years, having them ultimately owning about 27 acres when all was said and done. However, in 2014, a mortgage was filed encumbering the whole 200 acres. But at the time of that mortgage, as mentioned earlier, the couple no longer owned most of the land. A large title underwriter, First American Title, did the closing, and the mortgagee was Housing and Urban Development, as we know as HUD. And HUD would have thought that they were encumbering all 200 acres, when in reality, the mortgagors only owned that 27 acres of land. So luckily, Capital Lien called attention to it for our client during our research process, and they were able to file a corrective mortgage before the property sold. So prior to creating any presentation that we do, Mandy and myself, we like to reach out to the teams doing the work and get their input. So prior to the creation of this presentation, we asked our licensed abstractors what the most common issues are that they're coming across when researching. The three most common issues that they said they see are documents being recorded in abstract versus torrens, documents with correct legal descriptions not posted to the correct tract, and applying a satisfaction to the wrong original mortgage document number. Those are all very common. We can do our best to prevent these errors from having an effect on your final product by searching all indices possible and finding the missing pieces of the puzzle. We always like to bring any issues to the recorder's attention so that they can fix the errors if possible. So actually something also came up fairly recently to file under Strange But True, and I thought I'd share it since it's top of mind for me. One of our property research supervisors found an incorrect legal description on a document, causing it to encumber the wrong property. Through communications he made with the county recorder, it turns out the intention of the document was to encumber a property owned by none other than an employee of that very county's treasurer's office. So as we're discussing the issue while talking to them on the phone, we can hear, "Oh geez, that's Betty's property," in the background of our conversation. So it truly can happen to anyone. All right, we wanted to provide a brief touch on simple corporate due diligence as well. And one thing that we frequently see are entities that fail to file their annual or biannual renewals. Honestly, this is something that typically can be done online for free. However, if this simple step isn't completed at the proper intervals the State Department requires, it can lead to the entity being dissolved by the state. If this happens, it is usually quite expensive for the company to get reinstated. It's just as easy a thing that can and should be avoided. If you or your client do not want to handle this administrative task, be sure to discuss your options with a registered agent, as they most likely have some type of annual renewal service you can sign up for. Another thing to know regarding corporate filings is when you are completing the forms for a foreign entity, make sure that the addresses are accurate. The registered agent address should always be different than the principal place of business or address of any of the officers. The state jurisdictions will not reject it if the addresses are all the same. If the registered agent address is used as the principal place of business, it could mean that lenders will file a UCC in the wrong jurisdiction, since UCC statutes state to file in the state of formation. The last thing I'll mention for corporate due diligence is how important it is to pull a copy of the organic corporate documents. Even a plain copy is better than relying on the state website for all current and accurate information. We've seen loans almost close with the incorrect legal name listed on the security agreement because the state's corporate lookup online showed the wrong company name. It doesn't cost a lot to pull those records up front, but it sure can cost a lot if the loan closes on the wrong legal name. All right, so now's a good time to turn our focus then towards the UCC related due diligence. I'll hand it off to Mandy to take you through that at this time.
Thanks, Ryan. So most people in this industry know that a UCC gives notice to the public that the secured party has an interest in the personal property of the debtor. It results when a creditor lends to a debtor and the debtor pledges collateral. The important thing to note in terms of proper due diligence is that the UCC must be filed in the right place for it to be perfected. But how do you know where to file? Filing against a person or trust simply needs to be filed in the state that they reside. In regards to an individual, it's the state on their active driver's license or active state ID. Filing against an entity needs to be in the original state of formation, which is not necessarily the state that they're physically conducting business. For example, a company was registered in Delaware, but physically does business in Minnesota. The statute requires the UCC be filed in the state of Delaware only, not in Minnesota, but in Delaware. We have seen many instances where the secured parties would file the UCC in both state offices, but that's not necessary, although it's not harmful either. Keep in mind, Article 9 only covers filing requirements for security interests in personal property and fixtures, not for real estate filings. Fixture filings are recorded in the local land recording offices, and some things to keep in mind are that many secured parties prefer to file at the central and local levels to ensure perfection and priority, especially if the filing covers both types of collateral, both real collateral and personal collateral. Also, a UCC is not a legal document. It's meant to accompany an executed security agreement that is kept with the parties involved in the transaction. Now I can take you through some UCC issues we've seen over the years. A UCC is also commonly known as a financing statement, and in regards to what is required, it's really quite simple. Only 3 things are needed: the debtor's legal name and address, the secured party's legal name and address, and the collateral being covered, which can be a very specific list of property, or it can also be a very generic blanket statement covering all assets of the debtor. Some of the common mistakes we see on a day-to-day basis are when a name other than the legal name is used for a person or business, failing to file an in lieu of statement, and incorrectly filing on an assumed name. If you're unsure of which legal name to use, you can always file against multiple names on one UCC. For example, you can file against Robert Smith and Bob Smith as a second debtor. Just be sure to file on the exact legal name of the debtor. Avoid using common nicknames and abbreviations when filing UCC, as they can create a hidden lien. If you must file on the nickname, like Bob Smith, file on both the legal name and the nickname. And lastly, when you're searching, make sure you check all possible names and variations that might be out there. Okay, so let's touch on one of the revisions. This one permitted each state to choose between 2 options regarding individual debtor names and what would be accepted as the legal name when filing UCC. Alternative A lays out that the legal name of the debtor will be exactly as it appears on the driver's license or state ID, as long as that ID is not expired. It also must have been issued by the state that you're filing in. So if the debtor has a license in Minnesota, you would file in Minnesota, not in Wisconsin. The majority of the states have adopted Alternative A. Alternative B is a little bit more confusing. They allow for a few other ways to determine the legal name of the debtor. There are 3 ways to determine in this option. The first is similar to Alternative A, as the name simply stated on the driver's license or state ID. The second way is the name of the individual under current law, and the third is the debtor's first and surname. If you are filing or searching in a state that has adopted Alternative B, you must search all 3 potential ways of filing against that debtor's name to ensure total due diligence. For example, say the debtor's name on the driver's license is Robert B. Smith. The name under current law is Robert Bradley Smith, and the first and surname is simply Robert Smith. A search would have to be conducted on all versions of that debtor to ensure all potential liens are revealed. There are 7 states that have adopted Alternative B. So let's touch on some UCC-1 filing issues. There are a few case examples we can use in showing that the courts will hold a UCC seriously misleading if the UCC is not filed on the correct legal name, and that includes nicknames as well as spelling mistakes. In the first case example for Andrew Fuel, you can see that the last name was spelled incorrectly with only 1 L in the last name, and the court determined that this UCC was ineffective because the name on the UCC did not meet the standard which required the full legal name. In the second case, you can see that the UCC was filed on the nickname of Mike Borden and not his full legal name of Michael Ray Borden. The courts also deemed this UCC ineffective because the state requires the legal name to be used when filing. A nickname in this instance, like Mike, does not meet this requirement. This is a very quick way to lose perfection in your secured collateral interest. Farm Bureau Bank financed debtor Kenneth Pierce's purchase of a fertilizer spreader for about $15,000, attaching that collateral to its UCC-1. Unfortunately, in April of 2017, Kenneth filed for bankruptcy. In May of 2017, FBB timely filed a proof of their claim to the full amount. It was determined security interest was not perfected on this UCC. The debtor argued that the individual name filed on the UCC was incorrect, meaning not his exact full name on his driver's license. Since the debtor had Kenneth Ray Pierce listed on his driver's license but had signed Kenneth Pierce. One thing that is often overlooked is when a debtor moves out of state. When this happens, the secured party remains perfected in the new state for a grace period of 4 months after the date of relocation. During the 4-month period, the secured party absolutely should file an in lieu of filing in the new state of residence. Basically just filing a new UCC-1 in the new state. But it's important to make mention in the collateral area that this is an in lieu of filing, and it contains filing information from the original UCC. At times, some secured parties even attach the original UCC filing from the old state as an exhibit for reference. Here's an older example of what an in lieu of filing looks like when it's recorded. As you can see, they mention the original filing number information down in the collateral section, which continues the perfected filing in the new jurisdiction. So now I'm going to go through some more common filing issues. The two we see the most often in regards to UCC-1s are not filing on the legal entity name and incorrectly filing on a company's assumed name. To maintain proper due diligence, you need to ensure the exact legal names of the borrowers or debtors before you file any UCC. To abide by statutes, at the very minimum, you should be visiting the state's website to determine the legal name of your borrower's entity versus just taking their word for it. As mentioned earlier, the best way to find out the true and correct legal name for a business is to pull the entity's organic articles and amendments and see what's on the actual document. Obtaining amendments is critical to verify any possible name changes that the entity may have gone through. Keep in mind, the state indices can be inaccurate since they're all manually entered, so typos are possible. Most importantly, if a debtor changes their name or address, the secured party needs to file a UCC-3 amendment to properly update and maintain their position. Based on court rulings from Host America Corporation versus Coastline Financial, Inc., and In Re CW Mining Company, among others, it's possible these filings would be considered unperfected since the name indicated on the state UCC index does not exactly match the legal name of the registered entity. This company is registered in Wisconsin with U.S. The UCCs shown below do not contain periods after the U and after the S, potentially making these filings seriously misleading. You should never include DBA or AKA or FKA or the like as part of the name you're filing on. It will automatically become a hidden lien, and it will not be revealed in a certified search that would be requested by a bankruptcy judge should your debtor happen to default. This is an example of how not to file against a DBA name. The first debtor should be Good Dog, Inc., which is the legal business name on record at the Minnesota Secretary of State. And the second debtor should be separated out as the UPS Store 6160, which is the assumed name for that business location. The two names should not be combined as one debtor. This filing is absolutely a hidden lien. Now I'm going to go over some of the common UCC-3 mistakes that are made. As many are probably aware, a UCC-3 is a document with a purpose to change the UCC in some manner. In regards to common mistakes, over the years we've seen a lot of combo or multi-purpose filings, incorrect original filing numbers being used, and untimely continuations along with termination issues. One thing to remember is when filing a UCC-3, you always have to use the original UCC-1 number, not a previous UCC-3 number that may be associated with that same filing. A multi-purpose filing isn't exactly a mistake, and actually many states do allow for them. However, we do not recommend filing them as a state can miss part of what the secured party is trying to accomplish. The states that do allow for multi-action filings usually charge per action anyway, so you're safer filing each action on its own form. For instance, one form to continue the UCC and a separate form to amend the collateral. This is a screenshot from our database Direct UCC search system. I pulled up an example of what can happen with a multi-action filing. Notice there was a filing on January 3rd, 2012, and another filing right afterwards on January 4th, 2012. That happened because the Minnesota Secretary of State missed that there was a second action to this UCC3 filing located on the same form. One action was for a change to the secured party, and one action was for a change to the collateral. The original amendment had to be filed again on the 4th to make sure the second action was captured. The state requires there be a filing for each action, and they simply missed the second action. If there had been a separate form for each, it would have been clear what is happening with the two different amendments. If the secured party or filing agent was not paying attention, they would not realize that only part of what they were trying to do was accomplished. Another common mistake is attempting to file a UCC3 with the incorrect original UCC1 filing number. A few things can happen in this situation. First off, your filing can and will most likely be rejected, or at least be delayed in getting recorded until the correct filing number is determined. Secondly, if the wrong original number is used when filing a continuation, by the time the filing is rejected and returned to you, the UCC could potentially have lapsed. If this happens, lien position is lost, and a new UCC1 needs to be filed because a lapsed UCC cannot be reinstated for any reason at all. I've seen this happen more times over the years than you'd think. And lastly, if you use the wrong original UCC number, you could potentially amend the wrong UCC filing altogether. For example, if you record a UCC3 and the number's off by even just one digit, you could have just amended a completely different filing, unrelated to your debtor or secured party. This one's interesting. I actually just ran into this exact problem yesterday with one of my clients. Untimely continuations are one of the easiest mistakes to make and one of the easiest ones to avoid. UCCs are good for 5 years in most states, and if they are to be effective for an additional 5 years, they need to have a continuation filed. There is a window to continue that opens 6 months prior to when the UCC lapses. This is the only time that the UCC can be continued. Many times over the years, I've seen secured parties attempt to file this continuation either too soon, which is what happened yesterday, or too late, just outside of the 6-month window. Once the continuation is filed, the lapse date is extended 5 years from the previous lapse date. If you attempt to file too soon, the filing will be rejected, and there's a chance it may be forgotten about later on when it's time to file in the appropriate window. Now I'll take a couple minutes to go through one of the most incredible filing errors we have seen happen in the U.S. in regards to an inadvertently filed termination. Some of you may have heard or read about this well-known case. Back in 2006, GM entered into a term loan for about $1.5 billion in financing for which JP Morgan was the administrative agent and secured party of record. The loan was secured by a first priority interest in equipment, fixtures, etc., and proceeds at 42 GM facilities across the country. Following standard procedures, JP Morgan also filed fixture filing statements as well. It went on to file additional UCC statements covering a subset of its plans, including one filed with the Delaware Secretary of State, which was for the main term loan UCC1. However, counsel for GM inadvertently included the main UCC1 in a list of financing statements needing to be terminated. The error continued to roll on that list through JP Morgan and their counsel unnoticed until GM's filing for bankruptcy in 2009. During the bankruptcy proceedings, JP Morgan argued that the termination was inadvertently filed, and since it was unauthorized, it was therefore ineffective. Other parties then asked the court to determine whether the termination was effective and if JP Morgan was essentially an unsecured creditor at that point. After being appealed, the Delaware Supreme Court was given the question whether the filing of a termination statement is effective to terminate the security interest regardless of the filer's intent. The Second Circuit found that actual authority and intent existed in this case, since both the secured party and their counsel were aware of the list of termination statements to be filed, and that JP Morgan not only reviewed, but assented to all the terminations listed. The inadvertently filed termination statement resulted in the loss of a perfected security interest for JP Morgan on the $1.5 billion term loan. Obviously, this is still being hashed out in the New York Bankruptcy Court, most recent question being whether the collateral is equipment or fixtures. If the assets are categorized as equipment, the secured lenders may be out of luck. On the other hand, if the GM plan assets qualify as fixtures, local fixture filings or mortgage filings in various jurisdictions could protect the secured lenders. Since this case has already spun off into a number of issues for secured lenders, will be going on for some time. This leads us right into the necessity of post-filing verification searches. The best way to know that you have successfully or unsuccessfully filed your UCC-1 or UCC-3 is by running a search to reflect. This is also known as a post-lien search. By running a search like this, you can double check to make sure that the filing itself is of record and indexed properly. It can also help verify your lien position relative to other creditors if applicable. And finally, it closes the gap between your pre-funding UCC search and the new filing itself. We highly recommend conducting a search after all and any UCCs are filed. I'm going to hand it back to Ryan now to summarize as you absorb everything we covered today.
So to wrap up today's discussion, let me leave you with some final thoughts in regards to necessary research within the thousands of jurisdictions across the country. An incredible amount of different skill sets are needed to ensure the very best compliance in all of them. To know each nuance and be able to dedicate your time to them can be daunting with tight deadlines in the legal industry. And trust a provider to be your behind-the-scenes resource when true due diligence is needed. I hope you've enjoyed the handful of stories we've shared regarding real estate, corporate, and the UCC. It always amazes me how the small things can become large, costly problems. So while you don't need to sweat the small stuff, you do need to have a trusted resource and plan to prevent it from biting you in the butt. And it all comes down to this: where do you ultimately need to win? Well, oftentimes the most concise answer is in court. With that, I'd encourage all of you to email or call us as needs arise after this presentation. Mandy and I do thank you for attending our presentation, and we'd now like to open it up to any questions that have come up.
If anyone has any questions, this is Lydia again. You can use the chat feature that's there on your screen. If you don't see it on the top, you can see it at the bottom. There should be a button there for you to select chat. We'll wait just a few moments here. I just want to say thank you. As we're waiting, I just want to say thank you to Mandy and Ryan for this presentation today. We really appreciate it. We thank you all the attendees for joining this NOWS WebEd presentation. All the members that have registered through nows.org will receive 1 hour of general CLE to your professional development journal. And in 5 to 7 days, you will receive an email with a link to download your the PDF copy of the certificate of completion and also access to the session's playback. Susan Mano says this to you, Ryan and Mandy. She will probably have a question at a later date, and she said thank you for the webinar. So again, we do appreciate you, Ryan and Mandy, and thank you all attendees for participating today.
Perfect. Yeah, we realize not everything will come up right today, but as long as you have a resource to lean on it with future questions, you know where to find us.
Of course. All right. Thank you so much. Have a great day, everyone.
Yep. Thank you.
Thanks, Lydia.
Bye.